Good morning, counsel.
Good morning, Your Honor. May it please the Court, Teresa Anderson on behalf of the Commonwealth, asking this Court to reverse the motion judge's order allowing the defendant's motion to suppress statements. Here, the defendant did not clearly, unequivocally, or verbally invoke his right to remain silent. This Court articulated the relevant rule in the Commonwealth in El Monte in 2005 and applied that rule in Leahy the same year. A defendant must clearly and unequivocally invoke his right to remain silent.
Well, could you just explain this ambiguous head movement that they talked about?
Pardon?
Ambiguous head movement?
Correct. As Your Honors may see from the record appendix, I've included the DVD.
I did look at the DVD.
It's approximately 5 minutes and 15 seconds. The defendant makes a gesture with his head where he appears to look down.
He appears to shake his head no, and then the interrogating security officer says, okay.
Correct. And the motion judge made a finding that the head movement was a negative back and forth movement.
And one of the police officers also regarded it that way.
Correct. Although the other police officer did not. The other police officer at the motion to suppress hearing said, I didn't interpret the gesture at that time.
So does that create the ambiguity that one of the police officers didn't interpret it the way that the judge found, and that the other officer, in keeping with what the judge found it to be unambiguous?
It certainly it informs the ambiguity. And here,
so how do we decide that? Do we not defer to the trial judge's determination?
Not in this case, Your Honor. First, he applied the wrong rule. The proper standard is a clear.
As to determining what that meant.
We need to look to the reasonable police officer. And here, the second error that the motion judge made was he substituted his own judgment, not what a reasonable police officer in these circumstances would have found.
Which of the two was the reasonable police officer? The one who accepted it as a no, or the one who thought it was ambiguous?
And I think that they both can be reasonable, and the point is there that it is ambiguous. And even if in putting it in context, the gesture was in response to a poorly worded question. The question is, you just want to go home, so you don't want to speak. So you don't want to speak. And even if the defendant would have articulated a verbal no, that no would have been ambiguous in this context.
So you've looked at the video.
Correct.
And you say, oh, this is clearly ambiguous. He doesn't mean no, he doesn't want to talk. I
think my first argument is the gesture that he made is non-communicative. It's non-verbal. It does nothing to express anything.
All right, non-verbal doesn't mean non-communicative. It's non-verbal, we know that.
I think this specific gesture is non-communicative. It's not your typical left to right, my very emphatic no. It is shaking and looking down. And Your Honors can see from the video for your own. But then the second argument there is that even if it is intended as a no, even a verbal no in this situation would be ambiguous.
Why?
It also follows on a few more questions. You know, you don't have you explaining Miranda and asking what happens if I don't speak, being told nothing happens. Then he says, I just want to go home. Then the question that you state is unclear, and then no. A whole series of questions say, I want to go home, what happens, head shake no.
And I think
hard to see ambiguity, but
I think even if you back up two more questions before that, the defendant asks, what happens if I don't speak with you? And the interviewing detective says nothing. It's after then he says, I just want to go home, and makes his gesture. And it's at that point that the second detective, Detective Lyles, picks up on there might be some misinformation here, a miscommunication of what nothing means. Nothing doesn't mean nothing will happen to you, you're free to go home. Nothing means there will be no bad consequences if you decide to invoke your right to remain silent.
What was okay about her continuing to speak after an invocation of no, assuming for the moment that it was unequivocal and it was a no? Is that okay?
It is not okay. But here it is ambiguous. It is not an invocation. And even then, it seeks to clarify the defendant's statement. The defendant may intend by his head gesture, no, I do not want to speak with you. But we need to require the defendant to use his words. We need to require him to say, I do not want to speak with you.
So what would have been appropriate then? The officer should have said, do you mean no, you don't want to speak to us?
Precisely.
Is that what the officer did?
The officer sought to display any of this in misinformation or the questions that were not properly or didn't properly convey the meaning. When Detective Alberg said nothing. Again, she goes on to, it's her opportunity in the conversation to jump in and clarify. She sees that there may have been some miscommunication here. And it's in that context that she says, but nothing doesn't exclude you still from being charged and us detaining here. You'll be bailed.
The officer didn't ask, so do you mean you don't want to speak to us? Said, well, let me give you some more context here.
Not to that specific. She's going back a couple of sentences.
She's going back, well, let me give you some context here. Actually, something will happen to you. You're going to be held
Correct.
Arrested, and you're going to be brought to jail.
Correct.
And then said some more things, and then said, well, now do you want to talk to us?
And then the defendant continues and uses his words. And his words say, I don't know what's going on. I'm lost about what's going on here.
But do you concede that when there is ambiguity, the obligation of the police officer then is simply to not pursue further questioning, certainly not persuade him to speak, but simply to resolve the ambiguity?
I think where there is ambiguity, the best practice is to ask clarifying questions to resolve the ambiguity.
Which did not happen here.
They did, and they did in response.
Show me the clarifying question. I mean, I see Detective Lyles goes on. Then Detective Alberg says, I told Charles that I want to give the opportunity to express to me your side. That doesn't seem like a resolution of ambiguity. That sounds like I will ignore the ambiguity and I will attempt to persuade you to speak to me.
And I might be misunderstanding your question. Not necessarily the ambiguity as in, I just saw you made a gesture with your head. What does that gesture mean? That certainly would be a great follow-up question here, and that did not happen. It's the ambiguity in the defendant's confused about this situation. The defendant he expresses, I don't know what's going on here. What's the process here? Am I being charged with something? I want to know what I'm being charged with.
But the question was, so you don't want to speak. You say ambiguous head gesture.
Correct.
In a courtroom, if a person did that, we would say the court reporter cannot reflect a head gesture. You need to say yes or no. I don't see anything there to say, does that mean yes or no? Can you explain what the head gesture means? I'll ask you again, do you want to speak with me? I don't see any of that. I see an attempted effort to persuade him to speak. Well, first of all, do you agree that that's what's happening?
I disagree. I disagree there's an effort to make him speak. The effort is to inform him of what's going on here and let him make a decision. In this situation, a defendant makes a decision whether to invoke his right, whether to waive his right. It's not clear here that he's made a decision because he doesn't understand by his own words. I don't understand.
Where is the next time that the person is asked, do you want to speak with me? I'm looking to hear that I don't see. You would think that if they're trying to resolve the ambiguity very quickly, there would be an effort to say, okay, so let's be clear here, or do you want to speak with me or not? When do you say that next happens?
It's page 7 of the interview, and he says, we can't make a decision, we can't talk to you about anything until you make a decision. And returns to this,
Okay, so that's four pages later.
Correct. And in the meantime, they're answering the defendant's questions. What's going on here? What am I being charged with? I'm really scared. Am I being charged to go to jail?
Okay, so what's the rule you ask us to invoke? If there is ambiguity in the response, then the police...
If there is an ambiguity in the response in this pre-Miranda waiver, it's clear he has not waived any right.
Right.
In this context, he needs a clear and unequivocal and verbal response to invoke his right to remain silent. And again, that follows this court's decisions.
And when, but that's not my question. My question is when there is an ambiguous response to the question, are you willing to speak with me, then what do you say the police must do in view of that ambiguity?
The best practice for the officers would be to resolve the ambiguity by asking the targeted questions. I see you've made a head gesture. What are you intending to verbally what are you intending to communicate? Please use your words, as we tell children. We need to understand what you're trying to say. Have you made a decision? Is there...
And are you saying that best practice would not be required under Miranda or our case law, or are you saying that that is what is required? I mean, you use the term best practice. Does that mean that we should not require it?
I don't believe it is required because...
Okay, so what is required? when there is ambiguity, the law of, under our Constitution, put aside the federal Constitution, the law under our Constitution requires what?
Where there's ambiguity in an invocation to the right to remain silent. Again, there is no requirement. You can move then toward waiver, an analysis of waiver, where the Commonwealth must demonstrate a knowing, voluntary, and intelligent waiver, but that's a separate analysis. And so therefore, to get to that analysis, the best practice is to ask the follow-up question.
You're not answering my question. I'm saying, are you saying that there's no obligation to resolve
Correct.
ambiguity then?
Correct.
Okay,
I don't
so
think there's an obligation. I think it's the best practice.
You think there should be no obligation? You think that's also appropriate? That we clarify that the law is there's no requirement. If you
Correct.
want to, you can clarify. Otherwise, you can treat it like it didn't happen.
Correct. But it is in all the parties' best interest for us to clarify. It is in the Commonwealth's best interest here to clarify and to seek a valid waiver.
Why is it not in the Commonwealth's best interest to ignore the ambiguity and attempt to persuade the person to speak?
Because there is a different situation. There is the coercion, there are the factors that we are seeking to avoid, and there would inform the waiver analysis. If there's coercion at that point.
By coercion, what do you mean? I mean, coercion can be simply, I want to give the opportunity to express to me your side. It's important that you tell your side of the story. It's not coercion, that's persuasion.
And may inform whether the defendant's ultimate waiver is knowing, voluntary, and intelligent, based on the police tactics used, whether it overbore his will, and whether it was a valid waiver. Again, a separate analysis from whether the defendant invoked his right to remain silent. And I would point the court's decision, or point the court's attention, to several cases here. In Commonwealth versus Sakari, 434 Mass. 732, silence does not invoke the right to remain silent.
Was Sakari, refresh my recollection, had he waived his right, and then the question is whether he had then re-invoked it?
The defendant had not been under arrest. He was confronted with some incriminating information, and he says, "Lock me up." At that point, they reread Miranda rights. The defendant does not respond. For 20 or 30 minutes, the officers ask targeted questions about the substance, and the defendant does not respond. Sits down, slouches in a chair, 10 more minutes of that, and it's interpreted as the defendant appears to be thinking. Thereafter, he makes incriminating statements.
Okay, so what's ambiguous about that?
It's his silence. The silence does not invoke the right. Or his gestures here, his sitting down and slouching in a chair, do not invoke his right to remain silent. His silence did not invoke his right to remain silent.
But was that, in that case, did that question occur after he had made an initial waiver of his Miranda rights?
Not after he made the lock me up statement. He had been
He had given his Miranda rights in Sakari, right?
several times pre-arrest.
And he waived his rights.
In those communications,
Okay.
yes.
And then in the course of question and answer by police about what happened, he made no answer to a particular question.
For 20 or 30 minutes.
Okay. In this case, the police put a question to him. Today's case, the police put a question to him. Do you want to talk to us, right?
Correct.
That's not an investigatory question. That's a question that really they were having concerns about whether or not this guy was invoking his right to silence. So they asked him a question.
Correct.
About that. He shook his head no. What's ambiguous about that? It's in direct response to a question about whether he wants to talk to them. It's not silence. It's not a response to an investigatory question.
And first, that assumes that it is reasonable to interpret the gesture as a no. Even if the defendant had said no.
But the cases in which that analysis is followed are cases in which a defendant is either silent or does something, drops his head in response to a question by police about the facts of the case. This is a question by police about whether or not he is exercising his right to remain silent. It's an entirely different category of question.
So then I would jump up to both Almonte and Leahy. And in those cases, the defendant's statements in Leahy, it was, not right now, in a minute, I needed to figure some things out. In Almonte, the defendant's statement was, "I believe I've said what I had to say." And again, we can then analyze to the right to an attorney context, where the ambiguous statements where I was thinking I might need a lawyer and want to talk to him before talking to you. That's Morgantini. And the court has found that in those contexts, you need a clear and unequivocal invocation of the right to counsel.
Right, but that was after Morganti. He already had waived his rights.
I don't believe so. I don't believe that it was before his Miranda waiver. He said he understood his rights. He had not signed his Miranda form and says, "I was thinking I might need a lawyer and want to talk with him before I talk to you."
But do you agree that there's a difference between what's required before there's a waiver versus what's required after a waiver?
I'm not sure I understand your question. What's required?
What's required before the person initially waives his rights versus what's required when the person's already waived his rights and then may later be invoking the right to silence, having already waived the right to silence?
I understand your point, and I'm not sure what the span of time was between perhaps like an arrest and a booking and a interrogation, interview, Miranda warning. I'm not sure in that case.
Ms. Anderson, we'll have to leave it there.
Thank you, Your Honors.
Good morning, Your Honors. My name is Rebecca Jacobstein, and I represent Brandon Clarke. The judge below ruled that Mr. Clarke clearly invoked his right to remain silent, that this was not scrupulously honored, and that the statement must be suppressed. This court must uphold this ruling because the judge's ruling was not clearly erroneous. It was supported by the facts. And because although this court conducts an independent review of the conclusions of law, it also grants substantial deference to the lower court's findings.
Is it your view that this is not ambiguous at all? It's a clear invocation?
Yes, this is a clear invocation. He shook his head no, and under a reasonable officer in those circumstances would and did find that he invoked his right to remain silent. And
Now, is deference appropriate if we can see the videotape, just as he did?
deference is appropriate in this case, Your Honor, because the court not only saw the tape, but he saw the tape in light of the testimony of two people. And significantly, that court found that he credited Detective Alberg's statement that he believed he was ready to go, that he was done. The Commonwealth even argued at the motion hearing that he put down his papers, he was done, he believed there was a...
But if the standard is what a reasonable police officer would have done in the face of what's on the videotape, why is deference the appropriate standard? Isn't what a reasonable person would have done something that we can determine equally as well as the judge in this case because we have the videotape?
No, Your Honor, because Detective Alberg and Detective Lyles both testified as to their interpretation
Well, yeah,
of this head
but
shake.
it's not their interpretation that controls, is it? It's the reasonable police officer.
Well, that's true, but the
So
court
if that's
had to...
true, why isn't the videotape essentially the sole source of information upon which the decision need be made?
Because the court puts it in context by speaking through the testimony. And the court had to look at and did look at the totality of the communications between these officers. Detective Alberg was the lead detective in this case.
What if the defendant had clearly said no, and it's there on videotape, and the police officer said, gee, we didn't hear that, or we didn't interpret it to mean no? Do we listen to what the police officer's interpretation of no really meant?
No, you're absolutely right. That you would not. However, Detective Alberg, this was not Detective Alberg's only discussions or only communications with Mr. Clarke. Detective Alberg arrested Mr. Clarke. He transported him to headquarters. He took him out of his jail cell and brought him, and there was a communication that ensued between the two of them before they got to the interrogation room. So at that point, the judge could reasonably rely on credit his testimony that he would understand his communication style. And even prior to that, during their communications, during the interrogation, Mr. Clarke communicated via head gesture, and that was understood, and he said okay. So the fact that there is always going to be some context to the tape if there are prior communications that would inform Detective Alberg's reasonable understanding that this was in fact a no. Your Honors, today the Commonwealth is arguing that the police may ignore an invocation if they believe a person is confused. And basically they're saying that if the police are unclear not as to whether a person invoked but why they invoked, they can further question him. This is not the law, and this should not be the law. This is not the law because the police do not get to question a person's motives in asserting a constitutional right. And this should not be the law because it basically replaces the bright line rule of the scrupulously honor requirement with a subjective, muddy judgment call on part of the police.
Yeah, but I didn't hear her arguing that. I heard her arguing that it was ambiguous, that a reasonable person would view the head shake to be ambiguous, and that the ambiguity doesn't pose any obligation to clarify.
What they're saying is that it's ambiguous in light of these other things, and now that we're thinking about these other things, we think he shook his head no. We think he shook his head no because he thinks he can go home. Well, maybe he shook his head no because he wants to leave. But he shook his head no. He didn't want to speak to them. And why that was is not in any way relevant to whether or not he invoked.
Well, I mean, there are times in which police officers, like attorneys, are not terribly artful in their questioning, and sometimes they may ask two questions at once. And what if that happens and the person says no and the officer's not really sure which question the person's answering? Can they not, I mean, let's assume that there is some confusion as to what the no was in reference to. Police officer can't, I mean, what do you say is the obligation of a police officer in that circumstance?
I'm saying that the scrupulously honor rule is the rule. If there is if a reasonable officer would believe that's ambiguous, in the pre-waiver context, there should be an absolute obligation to clarify, because there is no presumption of waiver in that context. So if you're in the seat of the person who's being questioned, that person will think if they make an ambiguous response, it may not be ambiguous to them. They're probably not intending to give an ambiguous response. So if you're in that position and you believe that the police are just ignoring your response, as Justice Souter said, you may think that further assertions of your right are futile and give a confession, true or not, just to end the interrogation. And so the clarification is required so that the right to remain silent is scrupulously honored. If the person gives an ambiguous response, it needs to be clarified in the pre-waiver context.
This happened, I've sort of lost a grasp of the facts. This happened during the initial Miranda warning phase.
Yes.
Okay, yeah.
Right, so
This didn't happen in the course of an investigatory questioning that popped up like 15 minutes into the...
No, this is not about in the context that reasserting a right. This is about the initial invocation of that right. This is in the pre-waiver context. And because, again, in the pre-waiver context, there is a presumption against waiver, it must be any invocation must be scrupulously honored.
So basically what you're saying, if I understand you correctly, is that when it's unambiguous, no further questions.
That's correct.
If there's a question or a reasonable person in hearing the response could be confused about what was meant, then it's permissible to ask a clarifying question, like, what did you mean when you shook your head?
Right. I think that the police in this situation have two options. One is to clarify. The other option is just to assume invocation and to end questioning.
Right. So, and if there's any question about whether or not it was reasonable to think it was ambiguous, still, the clarifying question would be harmless.
In most circumstances, if there was no, are you sure you want to assert your right to remain, that kind of thing. Certainly if it was just, I'm sorry, I did not understand, do you want to speak to us or not, or I didn't hear you, that kind of thing, it would be harmless. Yeah. And in a lot of in the Almonte case, for instance, that was a case where there was clarification. The James case is another case where there was clarification. The person would ask a question. And in fact, in a sense, this case is one about clarification in that he said, do you want to speak to us? And Mr. Clarke said, I just want to go home. And that could have been seen as an assertion of the right to remain silent, though inartfully phrased. So he clarified, so you don't want to speak to us? And that's when he shook his head no.
And the reason why the ambiguity, I take it you're saying, is the reason why the ambiguity is important here is that the Commonwealth has the obligation to show that the defendant's waiver of his Miranda rights was voluntary, intelligent, and knowing. And in the face of ambiguity, that burden cannot be met.
Well, I'm not conceding that there's any ambiguity into his head shake.
Well,
no.
what if there were ambiguity?
Okay.
If there were ambiguity, isn't that as good as a no? Isn't that what you're saying?
Yes. I'm saying that if there, I mean, I want to be absolutely clear that this head shake no was unambiguous. It was not ambiguous. However, if it were to be found to be ambiguous, at that point, the police can either clarify the ambiguity or they can just assume that it's an invocation, because that would be how you would scrupulously honor a person's right to remain silent.
And are you characterizing what you think should be our Massachusetts law, or are you characterizing what you think is the present law under the Sixth Amendment in view of Tompkins?
Under Tompkins, I don't think clarification is required. I think that doesn't, however, need to be addressed. I don't think that the state rule needs to be addressed in this case because Mr. Clark's statement was unambiguous.
Okay, we know
Okay,
how
so we are
strongly you
clear as
feel
to
on
how I
that
believe
issue.
that.
Okay, but
All right.
so don't worry. There's no risk of ambiguity there.
Thank you.
But imagine for a moment that we were to take a different view, although we know clearly that you think we are wrong.
I can't believe it would happen.
I understand.
Were it to happen.
But if it were, do you agree that if you were to prevail, then you'd have to prevail under Article 12?
Yes.
And not under the U.S. Constitution?
Yes, Your Honor. Unless this court has any further questions, I will rest on my brief.
Thank you.
Thank you.